this January 15, 2025 meeting of the State Ethics Commission to order. We've got an agenda today that it looks like we've got 7 topics. Has everyone had an opportunity, all the commissioners had an opportunity to review the agenda? I think there are going to be a couple of changes based on what I understand. In part 4, under the consent orders, I have been advised that item B in the matter of Anna McCoy and item D in the matter of Stephanie Warmoth, those are not going forward because we do not yet have executed consent orders. Is that correct, staff?
Yes, sir.
Okay, so we've marked that off. That leaves items A, C, and E. In that regard, I've been advised that item A may require some technology assistance before it actually begins, so we're going to take it out of order. Item A is going to now be the 3rd item addressed on the consent order part of the agenda. We will begin with C, E, and then go back to A. With those changes presented, I'll make a motion to adopt the agenda as presented. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right. Item 2 on the agenda is review and approval of the meeting minutes from the last meeting of the commission on December the 13th of 2024. The minutes were distributed to all of the commissioners. Has everyone had an opportunity to review those minutes? Okay, I found 2 items that need to be corrected on the agenda. First, under commission staff who were present, although we would like Joseph Cusack to have still been here with us. I think we need to mark him off of who was present on the commission staff. And then also from the Office of the Attorney General, our regular counsel Elizabeth Young was not present, but Dana Yu was present. So with those 2 corrections, I'll move to adopt the minutes as presented from the last meeting. Do I have a second?
Second.
I got a motion and a second. Any discussion? All in favor say aye. Aye. Any opposed? All right, so we'll adopt those minutes as amended. We now have item 3 on the agenda, which is preliminary hearings. Are we prepared to move forward with that, Mr. Baywell?
Yes, sir.
All right, I'm going to go ahead and call then for preliminary hearing. It's case number 24-0058-C in the matter of Shakita Maxwell. It's my recollection, Mr. Baywell, that this matter was continued from the last meeting. Is that right?
Yes, sir.
What was the reason that it was continued?
Last board meeting, a few days before the board meeting, Ms. Maxwell contacted us. She said there was a death in the family and her family was going through the grieving process. So we continued the case from the December calendar.
Was she provided notice of this meeting being held today, January 15th?
Yes, sir. And I will get into that because she's not here, and I'll explain the circumstances. And before we get to the merits of the case, I'll leave it to the board members on whether we should continue or not.
Okay. Go ahead and proceed then, Mr. Baywell.
Yes, sir. And this, again, preliminarily, we're not getting into the merits of the complaint, but this case was originally docketed for the...
Let me interrupt you again real quick. Did she file any type of motion for continuance of this hearing?
Her and I informally have talked about this hearing, meaning through email. She had notice of the hearing, and she told me she couldn't make it. She provided an excuse. I didn't believe it was satisfactory, so I tried digging a little further and didn't make any headway with that. So what I told her is I will present everything I have to the board, and if they decide that we should continue the hearing, we're going to continue the hearing. I specifically told her that the information that I have to this point, I'm not agreeing to continue the case, but I would present everything to the board.
All right, so the way that I believe this should be treated then, whether it be formally or informally, is that what we're going to hear now is going to be on a motion for continuance by Ms. Maxwell.
Yes, sir.
So she hasn't presented anything in terms of any writing or anything of that nature to support her motion for continuance? It's only based on what she told you?
I have an email exchange with her, and I have a PowerPoint, so if the commissioners want to see the email exchange, they can. She did send me documentation of a 1:45 appointment this afternoon. And once I received that, I looked into it, looked at where she was going, looked at what she told me, and I didn't believe it was a satisfactory explanation as to why she couldn't be here. I also talked to Mr. Amati. I know the board's position on virtual hearings, and not saying that I told her we would have a virtual hearing, but I said we would at least consider, if the facts merited this, at least consider proceeding virtually. But I also left it at her, as of right now, there's no continuance. I'm gonna present everything to the board and let the board decide.
All right, this is what I would prefer that you do, however.
Yes, sir.
You tell me what reasons she gave you for a continuance. Start with that, and then give us your response to what I'm going to be treating as a motion for continuance.
Okay. She sent a document to me, or a little snapshot, showing that she first told me she had a test and medical appointment on January 15th, and I asked her to send documentation. She sent me a snapshot showing an appointment for 1:45 in the afternoon today, and the bottom of the screenshot that she sent me was a Pearson Center. So when I got that, first thing I noted is this is a 10 o'clock hearing, and she's saying she has a 1:45 appointment. When I Googled that, that was not a medical facility. That was a continued learning, it was a testing center, but it was educational. It was not medical. So then I responded back to her and I said, do you have a medical appointment? Because what you sent me does not appear to be medical. And at that point, she said, I'm not sending you anything about my medical health. It's protected by HIPAA. And I'm saying, if you have, I'm not delving into the specifics of your treatment or anything like that, but if you have evidence of an actual appointment, that's what I'd be requesting. She didn't provide anything in addition to that. The testing center that she has the 1:45 appointment for, it's a little over an hour drive from Atlanta. So in my opinion, she could appear today at 10 o'clock. We could have the preliminary hearing and be done by 11 o'clock, and she would be back in the Macon area around 12:30 the latest, and she has a 1:45 appointment. So in my position, I think she could appear personally. Alternative to that, I said if we get a little bit more information, or if you can show me that there's an actual medical appointment, we can do a new analysis, and if we need to, we can consider then going virtual. But we never got to that point because there was no follow-up after that. So the last thing that I told her is I said, at this point, I don't have enough information for me to agree to continue the hearing, but I will present everything that we have to the commissioners, and I will let them decide should we continue or not.
Mr. Amati?
Mr. Baywall, is it correct that this would be her third request for continuance in this preliminary hearing?
Yes, sir. This was originally scheduled for the September board meeting in Savannah, and we removed it because she was in police custody in August and September of 2024. She did contact us a few days before the Savannah board meeting, and that one was obviously canceled, but she did contact us a few days before. She said she was just released from jail, and she wanted to appear virtually for that hearing. But we had already published the binder, and being a couple days before the hearing, I told her, I've already continued that case. It'll be on the December calendar.
Any questions for Mr. Baywall from any commissioner? I'll go ahead and make a motion. I'm going to make a motion to deny the respondent's motion for continuance. Do I have a second?
Second.
Got a motion and a second. Any discussion? All in favor of denying the motion for continuance, say aye. Aye. Any opposed? All right, that motion carries. Mr. Baywell, you can go ahead and proceed into the merits of the case for the preliminary hearing.
Yes, sir, let me pull that right up. And this is the matter of Shakita Maxwell, case number 24-0058C. The violations that I'll be presenting to the board today, violation 1, respondent accepted an anonymous campaign contribution. This was charged in the original complaint. Violations 2 through 6 were later added through a notice of additional allegations. Violation 2, respondent failed to open and maintain a separate depository account. Violation 3, respondent failed to timely file her June 30th, 2024 election year CCDR. Violation 4, respondent failed to timely file her September 30th, 2024 election year CCDR. Violation 5, respondent failed to timely file her October 25th, 2024 election year CCDR. And violation 6, respondent failed to report campaign contributions and/or expenditures. Some background information: Ms. Maxwell was a candidate for Macon-Bibb mayor in the 2024 election cycle. She filed her DOI on March 1st, 2024. She was the unsuccessful candidate in the May 21st, 2024 primary election. This complaint was generated by the commission on May 10th, 2024, and we also provided additional allegations to Ms. Maxwell on November 11th of 2024. Some background information on how this case originated. I got this case from Mr. Cusack, who was still with our office at the time, but what Mr. Cusack reported to me is there was a member of the media outlet who contacted him and was just generally asking about whether somebody can receive an anonymous campaign contribution. He learned that it was Ms. Maxwell that they were specifically asking about. He pulled her filings, and what he saw prompted him to then get me involved. I completed my investigation and prepared the original complaint. That's how this case originated. The first thing I did is I pulled Ms. Maxwell's filing history. Macon-Bibb, their Board of Elections receives the filings and then they upload them to our system. They don't have Easy Vote or any other system, so the way they're publicly available, you can go to the Board of Elections and request all a particular candidate's filings, or you can view them on the ethics.ga.gov filing system. They're uploaded by the Board of Elections. What I did is I went to our website and I saw Ms. Maxwell's filing history. That's what I have on this page, just showing that she filed her DOI on March 1st, 2024. She filed a CCDR on April 30th, 2024, and then she filed an amended CCDR on May 9th, 2024. That was the status of her filing history as of May 10th, 2024, and this is still her status. Since this case originated, no additional filings have been made. I want to just draw the commissioner's attention. Originally, this started off with just the anonymous campaign contribution, but when I started reviewing the April 30th and the amended April 30th CCDRs, just looking at the CCDRs, I see some errors. On the summary page of the April 30th CCDR, she's reporting $3,575 in in-kind contributions and then $2,400 in actual cash contributions. And that on its face isn't incorrect. It's not that can't be possible. But then when you start looking at what she's itemizing for contributions and expenditures, it's not adding up. The itemized contributions that I have on the right side of the screen, if you first look at the donors that she's reporting, the first entry, she's reporting the donor as Macedonia Church Family. In the description of that contribution, she just gives cash collected from members. That's insufficient. You can't pull a group of contributors together and just say the church gave me $1,200. You have to individually itemize who your contributors are. So that's just one example of when I'm looking at the CCDR, I see a deficiency. The second entry, Maxwell Family and Friends, she's saying again, the description of this, cash collected from family members. Again, you can't pull a group of family and friends and say, these are my contributors. If you have contributions over $100, you have to itemize the donor's name individually, their address. She's also checking off monetary and in-kind in both of these boxes. You can't, it's either one or the other. You either have an in-kind contribution or a monetary contribution. You can't have both. If you report both, you're going to get discrepancies with your on-hand amount, and it's just not sufficient legally. Regarding count one, the anonymous contribution, this is the first evidence of that on the April 30th, 2024 CCDR. She has an itemized entry under contributions, and it appears to say anonymous. It's not perfectly clear handwriting, but you can make out the A-N-O-N-Y. You can make out the S at the end of that entry. And it
Which
just,
one is that again? Is it the second one on the?
this part right here, that
Oh,
I'm pointing to.
okay, thanks.
So this is the second page of the itemized contributions, but she has an entry and it appears to be anonymous. She just gives a generic date of March 2024, $3,000, cash to pay election fees. You know, it's a monetary contribution.
What does it say after the word anonymous?
I'm not sure what that says, to be honest with you. But this is what essentially the reporter was talking about when they contacted Mr. Cusack. And this is what Mr. Cusack and I both saw. It does appear to say anonymous.
Okay, go back over there to the microphone, but thank you.
I did have here the expenditures that were on the April 30th, 2024 CCDR. And again, you see the same errors where she's saying she's making expenditures to the Macedonia Church Family, to Maxwell Family and Friends. And those are obvious not vendors for campaign materials for somebody. I'm just noting that there's errors on the CCDRs that are going to need to be fixed at some point. But at this point, when I drew up the original complaint, my focus was just on the $3,000 anonymous contribution.
And there's nothing from prevent you from filing a new case based on the problems with the CCDRs, right?
Yes, sir. The April 30th, 2024 CCDR in the expenditures section, she also she's also reporting anonymous, March 2024, $3,000 campaign fee payment to Board of Elections. So it just looks like her pattern when she's reporting this stuff is she's putting the same entries for contributions and expenditures. But essentially she duplicated the entry that she put as a contribution. The April 30th, 2024 amended CCDR was virtually the same, except with the entry where she had previously put anonymous, or what appears to be anonymous. Now she put Wanda Middleton, and I later found out that this was her mother. So the amended April 30th, 2024 CCDR, this was filed on May 9th. Instead of an anonymous inscription for the contribution, she's saying Wanda Middleton, and then the bottom of that, it says family, loving mother. She did the same thing in the contribution section and the expenditure section on the CCDR. In addition, on the April 30th, 2024 amended CCDR, this is her handwriting, but the addendum statement, please accept my amended form from the April 30th, 2024 report. I did not disclose the donor of the $3,000 because I do not know the person. My mother gave me the cashier's check and paid the Board of Elections. I initially contacted Ms. Maxwell on May 10th, 2024. That's the date our formal complaint went out. When I send the complaints out, I also send an email copy to respondents, just because a lot of them seem more apt to respond by email than when they just receive the formal complaint in the mail. Within an hour or two, she contacted me back. She actually called me as I was leaving the office. This was a Friday. And I called her from my personal phone, and on the way home, I talked to her. I had a pretty good conversation with her for about an hour. The first thing that I discussed with her is I asked, do you know who the person was that gave the $3,000 to your campaign? What she told me is her mother, somebody came to her mother's house, gave her mother the $3,000 and said that this was for her campaign for mayor. I asked if
Was it cash?
she told me it was cash, yes. I asked, well, do you know who this person is? At this point, she had already received the complaint, so she knew, there was a law that says you can't receive anonymous campaign contributions. But I talked to her and I said, that is what the law says. If you do receive an anonymous campaign contribution, that money has to be turned over to the state treasury. So she did know the law. I did ask her if she had any idea who that person was, or if she could even, try and find out who that person was so they wouldn't be an anonymous donor. And she told me she wasn't there, she wasn't privy to the actual exchange of money, but she also said her mom told her they had never seen that person before. So that's essentially, with regards to the $3,000, that's where it was left off. That she doesn't know who gave the money, they gave it to her mom, and she has no way of verifying the donor's identity. In addition to that, I asked if she had a campaign bank account. And the reason for this is because looking at her CCDRs and seeing how legally insufficient they are, this is a case where you need to see where the money's coming from, where the money's going, so you could accurately complete the CCDR. She told me that she was in the process of starting a campaign account. This is on May 10th. She did tell me that the money she collected from church and family members, that money did not go through a campaign bank account because she was just in the process of setting that up. When I talked to her on that Friday, I did, go over the differences between in-kind contributions and actual cash contributions. I went through the differences of an itemized contribution versus a non-itemized contribution. And once you hit that $100,000 or that $100 threshold, how you report that. This was somebody who did not know how to complete the CCDRs. Granted, she was trying to. She just wasn't doing it correctly. So what I told her to do, she didn't have the financials. She didn't appear that she had any documentation or anything like that. I said, what I want you to do is I want you to take the weekend and I want you to make a list of every contributor to your campaign. I want you to make a list of every expenditure from your campaign. And I told her, this is not optimal. You need to have these records at or near the time contributions are made and expenditures are made. But the situation we're in now, this is the best we're going to do. But I told her, make a list, because I'm going to call you back on Monday when I get back into the office, and I'm going to give you some direction on filing your CCDRs. I made it absolutely clear to her that her April 30th CCDR needed to be redone. I also reminded her that June 30th was the next reporting date. I did follow up with her again on May 13th. She didn't have a great memory of people that were contributing to her campaign. She did have some where, I was starting to organize these contributions and expenditures for her. Okay, this person, if they gave over $100, you have to itemize their information on the CCDR. This block of people that are under $100, you don't have to report their names, you don't have to report their address. You can tally up all of these contributions, and you would enter that on the in-kind contribution box on page 2. So in total, I easily spent 2 to 3 hours initially with her, talking about her campaign's contributions and expenditures, reminding her she needed to fix the April 30th CCDR, reminding her that there's a June 30th CCDR coming up. And when I was even talking to her on May 13th, she was talking about active expenditures around that time, which would be on the June 30th CCDR. So this is somebody who was told, you need to make some fixes. I also told her that as of right now, the anonymous contribution, my hands are tied, the law is pretty clear, that's number 1, a violation. Number 2, that money needs to be forfeited to the state treasury. But what I told her is, I recognize she had a $5,000 campaign, and repaying $3,000 is pretty significant for a $5,000 campaign. I told her that we would probably be able to be flexible with other violations if she just cleaned them up, fixed them, and stayed compliant. The next contact I had with her after the June 30th reporting period, we had the 4th of July holiday and there's a grace period, but I did check to see whether or not she filed the April 30th or June 30th CCDRs, and she did not. I had phone and email contact with her on July 15th, 2024. The phone call did not go well. I reminded her that she still had the anonymous campaign contribution. I also reminded her now that she missed the June 30th filing deadline. She hung up on me. She called me all sorts of names, accused me of working with her competitors and the other side in the deep state, and I was just a bunch of horrible things. This case was, as I mentioned before we began the merits of this complaint, this was originally docketed for the September board meeting. I saw actually on a headline when she was first in custody, and so I was following her in August and September of 2024 just to see whether or not she was still in custody, whether we'd be able to have the hearing or not.
Just move to the bottom part of that. When we talk about the terminating her account, we've already covered the.
Yes, and so this September 24th email exchange, I reminded her again, your April 30th CCDR is still insufficient. You never filed the June. The next report date is September 30th. And I told her, you either need to get these filed or you need to terminate your campaign account. I said, I don't have any financials. I don't know the specifics of your campaign, but by law, these are required. You're either going to have to file them, or there's going to be penalties that are attached. Nothing was filed. On November 11th, that's when the additional allegations were served, and these are violations 2 through 6. When you add they're added on to the original complaint. On this slide, I just have them labeled 1 through 5. This is when the additional allegations originated. The applicable law in this case, OCGA 21-5-30E, this says that the making and acceptance of anonymous contributions are prohibited. That is a violation of our law. In addition to that, I didn't charge this specifically, but under 21-5-30A, it does say that contributions received by a candidate have to be given directly to a candidate. There's no indirect or third-party contributions, which sounds like happened in this case. The applicable law for violation 2, failing to open and maintain a campaign depository account, OCGA 21-5-30C specifies that contributions received pursuant to the Act need to be held in a campaign depository account. I will say too that in this particular instance, this is how you can check to see that money is coming in legitimately and going out legitimately. And in this case, you know, based on the filing that was made April 30th, there's $5,000 plus of cash that's come into this campaign, and we have absolutely no verification, other than the qualifying fee. You know, I think that was legitimately paid, but still, there's between, you know, $2,000, $2,500 of cash that came in, where we're, you know, taking her word on whether, you know, who was paid, whether it was legitimate or not. So that is an important violation in this case. Violations 3 through 5, OCGA 21-5-34C2A. This is just the filing schedule for candidates during the election year, and the specific dates that were missed, April 30th was filed, it was insufficient. But since then, respondents missed June 30th, September 30th, and October 25th. Violation 6, failing to report campaign expenditures. OCGA 21-5-34B just sets out how contributions and expenditures need to be reported. At the end of the day, all your contributions and expenditures need to be reported. Now, whether they're under $100, they can be reported in bulk and just totaled up. If they're over $100, there's additional information you need to provide. The donor's name, address, occupation, employer, the date received, as to any expenditures, the recipient's name, if they're an individual, their occupation, their employment, the general purpose of the expenditure. And in this case, the evidence that I have,
So, I mean, we don't even know at this point whether there was a commingling of the money, right? With regard to personal expenditures.
I mean, if the money's not in a depository account, it's in the left pocket. For purposes of violation 6, these are just some of the evidence of campaign spending that I saw. And what I put up on the April 30th and the amended April 30th, that's the extent of what she's reported. So essentially nothing is reported. But I did find evidence on her social media. First off, she was advertising the website, the official Maxwell for Mayor, Macon-bidcounty.com. And when I talked to her originally, May 10th or May 13th, she did indicate that this was an expenditure, that she was in the process of setting up an internet page for her campaign. So that would be either a in-kind contribution or expenditure that's not reported. The photo on the right, this was taken from social media. It was posted May 21st, but this appears to be a newspaper advertisement that was run. The next page on the left, it appears to be some type of advertising business card. There's possible photography charges here, graphic design for the advertisement, printing. The picture on the right shows a different advertisement. That does look like can't make it out great, but it looks like there's a stack of advertisements on the table, vote Maxwell for mayor. But again, there's possible photography, graphic design, printing costs associated with those. And those would be 4 pieces of evidence that I believe show that there were campaign contributions or expenditures that were not reported. So the last slide I have for the board, and before the board votes, is just a reasonable grounds finding for each of the 6 violations that I referenced today.
Does anyone have any questions for Mr. Babel? Which number did you hit? Will you hit your button?
18. On the anonymous donation, the amended complaint lists her mother as the donor. Now, if that money was actually the mother's funds, we wouldn't be here, at least on that complaint. That would solve that problem. But then she notes her mother was really a conduit for other unknown people. So that didn't solve the problem.
Yes, sir.
In fact, as you alluded, it creates another problem that we're not.
Yes, sir. And the only thing I'll add is just the timing of that. She filed the amended complaint on May 9th, before anybody had contacted her, before we sent out the complaint. And then on May 10th, before I did the complaint, I went back on the e-file system and I saw that she filed the amended CCDR. And then I saw the explanation that she gave, I do not know the person.
And then as far as you can tell, this is my second question, the family and friends donation and the church donation is separate from the anonymous. Those
Yes, sir.
are three different donations.
Yes, and I did talk to her, and one of the things I warned her, I said, passing the hat at church, or, passing the hat amongst family and friends, I said it probably puts a candidate in a very difficult position of knowing who's giving, how much they're giving. That in and of itself isn't a violation of the law, but you're probably putting yourself in a good position to violate the law doing that. But she did say they were separate contributions that she received from a block of church members. That was one pool of money she received, and then family and friends, that was a second pool that she received.
All right, I'll just leave with one last comment. It sounds like you've been remarkably patient
I have.
with this candidate. I don't
This,
think of you as
just
a
some
deep state at
background.
all.
Well, it
And
started out,
humble too, clearly.
it started out with, she was saying, somebody set this up, or my opponent did this, and I let her know that, I haven't talked to her opponent, we don't pit public official against public official to try and build cases against each other. And I just told her that my boss told me somebody from the media contacted him. They weren't adversarial, they were just inquiring whether somebody can receive an anonymous donation or not. So I informed her, if you think I'm working with somebody or in cahoots with somebody, you're mistaken. I've never been to Macon, I don't know a single person in Macon.
That's all.
Any other questions or comments for Mr. Babel?
I'd like to say you're one of the most patient people I've been.
Well, thank you.
I got it. All right. I'm going to go ahead and make a motion. I'll make a motion that we find that reasonable grounds exist that the Campaign Finance Act was violated when the respondent received an anonymous campaign contribution in the amount of $3,000 in violation of OCGA 21-5-30E. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? That one carries. I'll make a motion that we find that reasonable grounds exist that the respondent violated the Campaign Finance Act when she failed to open and maintain a campaign depository account in violation of OCGA 21-5-30C. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? I'll make a motion that we find that there are reasonable grounds that exist that the Campaign Finance Act was violated by the respondent when she failed to timely file her June 30, 2024 election year CCDR in violation of OCGA Section 21-5-34C2A. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? That motion carries. I'll make a motion that we find that reasonable grounds exist that the respondent violated the Campaign Finance Act when she failed to timely file her September 30, 2024 election year CCDR in violation of OCGA 21-5-34C2A. I got a motion. Is there a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion carries. I'll make a motion that we find that reasonable grounds exist that the respondent violated the Campaign Finance Act when she failed to timely file her October 25, 2024 election year CCDR in violation of OCGA Section 21-5-34C2A. Got a motion. Is there a second?
Second.
Got a motion and a second. Is there any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion carries. Last motion. I move that we find that the reasonable grounds exist that the respondent violated the Campaign Finance Act when she failed to report campaign contributions and/or expenditures in violation of OCGA Section 21-5-34B1. Got a motion, is there a second?
Second.
Got a motion and a second, is there any discussion? Hearing none, I'll call the question, all in favor say aye. Aye. Any opposed? That motion carries. Mr. Baywall, again, I applaud you for your patience in this, but by that same token, it looks to me like there are issues that are out there that remain with respect to this particular candidate. And, just because we, had a preliminary hearing on certain grounds, I don't think that necessarily means, that additional grounds can be ignored.
I understand.
Anything else with regard to the preliminary hearings? Anything from the staff? Again, thank you very much, Mr. Baywall. We're going to go ahead and move to the consent orders. Again, I'm going to take items C and D first. Mr. Baywall, it looks like you've got item C, is that right?
Yes, sir.
I'm going to go ahead and call this case. It's case number 24-0125C in the matter of Doug Ingram.
Mr. Ingram was a candidate for Mulberry City Council in the 2024 election cycle. This was a third-party complaint our office received. The allegation was that he failed to file his personal financial disclosure statement within 15 days of qualifying for office. Mr. Ingram contacted us immediately. He was cooperative. Just explained that it was an oversight. This is the first time he ran for city council. He had no public official experience in the past and just was unfamiliar with the rules, but very cooperative. He immediately got the PFDS filed, and he agreed to this consent agreement here. For the one PFDS violation, he's agreeing on paying a $125 late fee, $125 civil penalty, total penalty of $250.
We have an executed consent order by both sides.
Yes, sir.
Have those fines been paid yet?
Mr. Ingram, I believe actually he did just pay them at the end of last week. I think so, yes.
Okay. Mr. McCarter, it looks like you've got item number E, case number 24-011C-C in the matter of Lorraine Cochran Johnson.
Yes, Ms. Cochran Johnson ran for CEO of DeKalb County in 2024. This was a third-party complaint, and it was alleged that she filed late her April 30th, 2024 CCDR. Ms. Cochran Johnson reached out immediately to me as soon as she learned of the allegations, and she admitted that there was some oversight in her campaign. And she immediately had it filed, I think within the next week. So she was immediately cooperative, and we agreed to a $250 late filing fee.
Do you have fully executed consent orders on that one?
Yes, sir.
Or consent order, I should say.
Yes.
That one. Has the fine been paid?
As far as I know, I don't believe so, but I will follow up.
They generally have 30 days from the date of the order, right? Yeah.
I'd just like to find out.
Sure.
Which number is it? Okay. So we've got items C and E that have been presented. Under the Hicks rule, I'm going to treat those together. I make a motion that we accept the consent order on item C, 24-0125 in the matter of Doug Ingram, and the consent order in item E, 24-0116-C in the matter of Lorraine Cochran Johnson. I may have lost track of my motion, but I move that we accept those consent orders. Do I have a second?
Second.
I got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Both consent orders are accepted and approved. Yes, sir. We're actually going to, but I appreciate that. We're going to be in recess for a short amount of time for technology purposes.
All right, good.
I'm going to call this meeting back to order. We're still in item 4 on the agenda. We've got one last matter to address, and I believe we're ready to go on that one. I'm going to go ahead and call case 2019-0050PC in the matter of New Georgia Project, Inc. and New Georgia Project Action Fund, Inc. This is Mr. Amati's case.
Thank you, Mr. Chairman. I will present on behalf of the commission. If for no other reason, I think I'm the only one left since the time this complaint was filed in September of 2019, although I see Mr. Cusack in the audience. I'll start by
From the
saying,
commission staff, not the commissioners.
correct. You were also here, correct. I'll start by saying I have a presentation for the commission in support of this consent order. I'm asking you to vote on. It won't be terribly lengthy, certainly not as lengthy as Mr. Cusack's 133-page PowerPoint that we heard from and saw in 2022 at the preliminary hearing. But given the fact that 2 of our 5 commissioners are new to the commission since that case was heard, and the complexity of this, I think showing some of the evidence that we had to support the findings of the violations of law would be helpful. And to be clear, I'm only presenting a handful of pieces of evidence on some of the relevant documents. I'm certainly not going to take through the board through the reams of evidence we collected, but I think this will be helpful. So we'll start with the procedural. Okay, of course it is. By the way, I mean, it was just working.
It was just working. On and off, David. There's on and off.
I mean,
As long as you're working on technology.
The pointer,
no, the pointer's working. I'm saying it's not clicking.
Commissioner White?
Is anybody here from New Georgia Project or?
It's my understanding that there's one person that is actually attending by Zoom. They will be given the opportunity to speak if he chooses to do so. I believe it's Mr. Fox, right?
Correct.
Yes.
Thank you.
We took a break and everything to get ready for this, and we still got the tech wrong.
I guess I'll go ahead and ask this. Mr. Fox, are you able to hear us okay?
I can hear you. Are you able to hear me?
Yes, thank you very much. Absolutely. Thank you.
Thank you.
Why don't you, Mr. Fox, before you mute yourself, why don't you go ahead and just state your full name for the record?
Yes, I'm David Fox with Alliance Law Group and counsel for the respondents in this matter.
Okay, thank you.
So, go ahead and move to the second slide. We'll just have Mr. Yavin sort of drive for us up there. I mean, tech always ceases to amaze. So, we'll start with the procedural history. This case was originally filed by the commission on September 9th, 2019, alleging failure to register as an independent committee by New Georgia Project and its affiliated action fund during the 2018 statewide election in both the general and the primary election. It further alleged they operated as a ballot committee, unregistered and unreported, during the 2019 MARTA referendum in Gwinnett County. It took an extensive period of time of litigation in both Fulton and Gwinnett County Superior Courts, as well as the Court of Appeals. But ultimately, subpoenas we issued did return bank records from this organization in March of 2022. Following receiving those bank records, we amended the complaint with specificity now that we had the financial information. And that amended complaint was filed on June 17th of 2022. The case was brought forward before the full board for a preliminary hearing on August 1st of 2022. And at that hearing, the commission voted, following extensive evidence being presented, that there was reasonable grounds to believe that the law had been violated in all the manners that the respondents had admitted to in this consent order, including that they illegally raised over $4 million in contributions without disclosure and expended over $3 million without disclosure during the 18th cycle, which was a statewide election, of course. And as you see on the screen, over $646,000 was raised and not disclosed publicly or to the commission in the MARTA referendum, with a little over $173,000 in expenditures that they failed to disclose during that time period. On this next slide, we'll see that following that preliminary hearing on August 1st of 2022, and at that hearing, this board voted unanimously 5-0 to find reasonable grounds the law had been violated. Following that hearing, the respondents filed suit in federal court alleging and seeking to invalidate state law regarding independent committees and ballot committees and their disclosure and regulation. Ultimately, the 11th Circuit Court of Appeals ruled in our favor 3-0 to dismiss their suit and return the case to the state for further prosecution. And that order came down on July 8th of 2024. Since that time, this case has been in front of the administrative law judge. The ALJ has granted stays of the full hearing and trial pending settlements negotiations, and that stay actually expired January 10th, but given we were able to reach a resolution before that, we got some grace from the ALJ to put this on the first commission agenda following that date, which is today, the 15th. We can go to the next slide. Operative law in this case, an independent committee is any committee, club, association, corporation, partnership, union, or other group, other than a campaign or political party, that seeks to advocate raising and spending money to influence the results of an election. And when we say advocate, we're talking, of course, of express advocacy. These groups are commonly referred to as super PACs in sort of public nomenclature. And they, unlike campaign committees, can raise and spend unlimited amounts of money to influence an election, not subject to contribution limits, if we go to the next page. If an organization is electioneering in Georgia as an independent committee, they have to register with the commission, they have to disclose the money they raise and the source of that money, where they're bringing in their dollars from. They have to disclose how they're spending that, and they have to indicate in the disclosures what elections they are advocating the election for or against, and name the candidates. There are periodic reports, so in this case, there would have been a report the first day of the month, 2 months before the election month, another one the first day of the month, 1 month before the election month, another report 2 weeks before the election, and then from that 2-week period to the election in both the general and the primary, any expenditures over $1,000 would have had to be disclosed within 2 business days. And again, they have to disclose donor information, the names of their donors, occupation, employment, etc. If we can go to the next slide. Similarly, ballot committees are committees that accept contributions and make expenditures. Unlike independent committees, ballot committees have a threshold, commissioners, and so only after a ballot committee, which is seeking to influence a referendum or a question on the ballot, spends over $500, that's when those entities have to register and start disclosing the source of their funds. Independent committees don't have a threshold. The moment they start spending, they need to be registered and disclosing. As it relates to both ballot committees and independent committees, all advertising, all electioneering literature, whatever it is, has to disclose in writing or audibly the name of the officer of the campaign committee and who paid for that particular advertisement. Go to the next slide. So here, I'm going to spend a couple of slides showing evidence that we collected during this investigation of express advocacy and electioneering activity. Here you see during the general election, this was I believe this was just a campaign mailer that they ordered advocating. And at all times during this 2018 cycle, both the primary and the general, this group was advocating for the election of Stacey Abrams for governor. During the general, they did do some slate advertisements where they also, down on the ticket would list other individuals. So on this particular advertisement or literature mailer, you see Sarah Riggs Amico for lieutenant governor, Osa Thornton for school superintendent, Richard Keatley for labor, and on. Lucy McBath, Ginger in the same park, and Matt Wilson. We can go to the next one. And in this literature, it also, you see that there's sort of talking points and reasons for people to vote for the people that they are endorsing. Here we see an example from social media of their canvassing and direct voter contact or door knocking operation. I'll show you in a moment how extensive that direct voter contact, that door knocking operation was, but it was pretty robust. This appears to be a canvassing door knocking team in South Metro Atlanta from September of 2018, where they were clearly advocating for Miss Abrams' election. Tagged in this post was the registered agent and director of the New Georgia Project at the time, Insay Ufat. And this comes from the page of the Action Fund, and I'll explain a little bit later how those two entities are effectively one and the same for purposes of this case. But we can move to the next slide. Election of, I think these are door knockers, so not mailbox mailers, but canvassers would leave these on the handle of doors as they visited the homes. This is a different actual slate advertisement than the one we saw earlier. Different candidates. It doesn't appear there are any federal candidates on this one. But again, you see Miss Abrams for governor at the top, and then several other statewide candidates on the Democratic ticket as well. I think we can go to the next one. And I'll just point out on that last slide, it did note in the post thousands of doors, thousands of voters. which drives to the point of the robust operation. Here we have a social media posting from October of 2018 where they were advertising to hire canvassers and door knockers for the Abrams initiative by New Georgia. This again just shows that they are not just raising money, but they're expending money. They're hiring staffers to come on board to knock doors, direct voter outreach, and contact. Go to the next slide. This is another social media post. This one from September of 2018 was evidence we uncovered of phone banking. They also engaged in phone banking, this one in conjunction with the Working Families Party. And it looks like there was a phone banking set up on a weekend from 11 to 5 p.m. in late September between the New Georgia Project and the Working Families Party Alliance. Next slide. Here we see a social media post from late October, so just a few weeks before the election, and it shows that the organization actually had field offices statewide. They had field offices in Atlanta, of course, but they also had field offices where they had canvassers and staff, again, door knocking, phone banking, direct voter engagement in Norcross, Tucker, and Riverdale, as well as Atlanta, but as far east as Augusta, and as far south as Macon, Columbus, Dawson, and all the way down to Albany. So you see, I think they had at some point about 10 or so field offices throughout the state where they could engage in direct voter contact to advocate for Ms. Abrams' election. Next slide. So this slide and the next one are going to be examples of items we received via subpoena of scripts, and it's a little hard to read here, I know, but anyone who wanted a paper copy has one in front of them. This is a script from the primary election in 2018 of what their door knockers were supposed to basically say and advocate to the voters they came in contact with. And during this election, this was obviously an endorsement of Stacey Abrams in the script to the detriment of the Stacey Evans campaign for governor, who was her primary election opponent in 2018. There's also talking points about different subjects, public safety, education, transportation, affordable health care, and it appears in the script that depending on what the voter may indicate is their most important or pressing issue of that election, they could enter a number or a code and feed that into whatever electronic system they had. On the next slide, you'll see similarly, when it went blank, just kind of move the mouse. Here you see, no, go back. There we go. So here you see a general election script. This is one of the scripts that the canvassers had during the 2018 general election, advocating that they were, on behalf of New Georgia, endorsing Stacey Abrams for governor, discussing the reason, this is just the first page of that script, but discussing the reasons to vote for Stacey Abrams, discussing polling location, voting dates, etc. And you see there it has talking points, and you can use the IDs to punch into the system they had. Interestingly, on this one, you see it actually tracks how many doors and people they've interacted with. So on this particular date for this canvasser, which was November 1st, just a few days before the election, by 12:42 p.m. it appears that canvasser had knocked on 92 doors and interacted with 130 different people, presumably voters in Georgia. Next, we have a social media post from late October of 2018, where they're actually fundraising. So there is the post above of what they're saying. That was the night of the debate between then Secretary Kemp and former Representative Abrams. But in the box below that they're quote tweeting, you see it's actually an ActBlue donation link. And so they were not only soliciting donations from private donors, but they were publicly soliciting smaller dollar donations in social media with the general public. And you see, and we'll talk more about that donation link and the bank and the fundraising mechanism, but you see that there is a link to raise money that they are sort of pushing publicly. And if we go to the next slide, you'll actually see, again, this is on the same night, about an hour later, the night of the debate, another link to their ActBlue account asking people to donate so they can get the word out on behalf of the Abrams campaign, or the Abrams, the election for Ms. Abrams, and they provide the ActBlue link there as well publicly. We'll go to the next slide. Okay, Yeah, so this is just one piece of evidence in the same vein as the 2018 election. This is from the 2019 election, showing that like in 18, we have a canvassing and door knocking field operation that the New Georgia Project was and its action fund were engaged in. That included door knocking, phone banking, other forms of social media outreach to create direct voter engagement in the 2019 MARTA referendum. In this post, I believe, and this was limited to Gwinnett County, but it highlights that this particular set of mailers or door knockers they're handing out is actually Spanish literature. So again, it was sophisticated enough they could target, which demographic, which language the voters they were in the region were would be most effective. And that's just to show that there was the same electioneering activity evidence we uncovered from 2018 and 2019 as well. So the next couple of slides are going to be documents from the Secretary of State's records, the corporate records from the Secretary of State. The New Georgia Project was founded in 2013 by Ms. Abrams as a division of her corporation, Third Sector Development. It later incorporated independently on its own in 2017. This is from 2018's filings with SOS that show NSA UFOD again as the registered agent. You've seen a lot of the literature is in the name of the Action Fund, but we'll show that, and what the evidence showed, is that the money all flowed actually through New Georgia Project. So if you remember, the Action Fund tagged Ms. Ufot, but Ms. Ufot was the director and head of New Georgia Project at the time of the election. And on the next slide, and they were headquartered out of 165 Cortlandt Street in a particular suite. This next slide shows that the Action Fund itself did not incorporate as its own entity in Georgia until 2020. So it effectively operated as an arm of the New Georgia Project, and we'll show in just a second that all the money going in and out, all the billing, all the vendors were being directed to New Georgia Project. And this is just the slide of Third Sector Development, which was the organization, Ms. Abrams' organization that founded New Georgia Project. And this is from 2018 as well. You can see that while New Georgia Project incorporated separately, if you look at the address, the corporate address, the principal office, New Georgia Project remained at the same office as Third Sector Development through the election. So before we play this video, you've seen that pretty much all the literature in social media and canvassing appears in the name of the Action Fund. But as this will show, it's actually the website of the New Georgia Project Action Fund. You can go ahead and I'll just talk through it as a place if you can hit play on it. So when people go to the Action Fund's website, you see on the top right, there's a donation button. If you actually seek to donate to the Action Fund, which it does here, it doesn't take you to an Action Fund link. It actually redirects you to the New Georgia Project. So even entities trying to donate to the Action Fund were actually directed back to New Georgia Project and the C3. So all money going in and out was solely limited to and was controlled by the New Georgia Project for all expenditures and contributions. Similarly, if you actually seek to learn more about the New Georgia Project Action Fund, which you will in a minute, you hit the Learn More button. Again, it takes you and directs you to information and literature on the New Georgia Project page. So as we saw in this investigation, these two entities had different names, were affiliated, but effectively were one and the same for purposes of this case in the 2018 and 19 election. So we can go to the next slide. So more evidence of sort of the overlap between the New Georgia Project and the Action Fund as it relates to all of this electioneering activity in support of Ms. Abrams. Here we have a check for canvassers, door knockers in 2019 during the MARTA referendum, wearing the Action Fund t-shirts with the Action Fund literature, but if you notice the check is actually made out from the New Georgia Project, Inc. I don't know that the Action Fund had a bank account at the time, but certainly any activity they were engaged in was being flowed through the New Georgia Project itself, and they had full control of the money in and out, whether it be for canvassers, phone bankers, literature, social media outreach, whatever that may be, it flowed through the New Georgia Project. And on the next slide, We have a couple checks for canvassers and door knockers from 2018. These are just a few of the many checks we had. But you see again the canvassers and door knockers in 2018, these being from the general election in November, were all made out from the New Georgia Project. Financial records showed that, again, not to beat a dead horse, but this all flowed through the New Georgia Project, controlling all this. Okay, can we go to the next slide, Erwin? It timed out again, it's blank. You just gotta move the mouse around. Okay, there it is. So more evidence of the overlap. There we go, perfect. More evidence of sort of all of this being controlled and flowed through the New Georgia Project. This is a particular invoice from October of 2018 for 50,000 door hangers, door knockers, for the canvassers to distribute. So you see this invoice, this particular invoice, about $4,500 for 50,000 door hangers. That the New Georgia Project Action Fund distributed, but if you notice, it was actually billed to the New Georgia Project and was paid out of the New Georgia Project's operating account. And in the next slide, we see another set of 50,000 palm cards that were invoiced a few days later, leading up to the general election, to be handed out by door knockers. This again looks like it was a little over $4,000 for this set of 50,000 palm cards. And again, while they may have been wearing Action Fund t-shirts, for all practical purposes, again, it was billed to the New Georgia Project and paid by the New Georgia Project. We can go to the next one. Here we have an invoice similarly to those. This is an invoice from the 2019 MARTA referendum. This appears to be a set of a total 50,000 pieces of campaign literature for the MARTA referendum. Some of those being palm cards, some of those having sort of themes. You see one was Super Bowl designed at the time, one being a Valentine's Day themed palm card. But these 3 reasons palm cards add up to about 50,000 pieces of literature. This invoice came in February 2019 ahead of the MARTA referendum that spring. And you see it came in February 11th, and if you go to the next slide, you'll see that it was actually paid out of, again, by the New Georgia Project Inc.'s fund 4 days later to Hicks Evaluation Group for their work on that. And on the next slide, you see the actual piece of campaign literature tied to that particular invoice of 50,000 palm cards, this being the 3 reasons palm card for the MARTA referendum. We can go to the next one. So this is an affidavit we received from a former employee at the New Georgia Project named Stacy Hopkins. She was the office manager of the organization at the time and provided us with a significant amount of information during the course of the investigation. It's not relevant now because they've admitted to all the allegations and all the violations of law, but at some point there was a claim or defense that they were a subcontractor for another group. In this affidavit, Ms. Hopkins clarified that those materials were never distributed by canvassers. It was only New Georgia Project materials that were distributed during the primary election of 2018 that she witnessed and observed, as well as the general. And in the next slide, this is just a text involving a vendor and Ms. Ufot, who was running the organization, sort of that verified that Stacy Hopkins was the manager, Ms. Ufot directing all of those packages to be delivered to the witness in the case. So as you see in the consent order, they've admitted to 16 violations of law. They've admitted they failed to register and therefore spent unregulated and unknown monies during the 17 and 18 election cycle, or the 18 election cycle, but the 17 and 18 election years. As an independent committee, they failed to file a number of disclosure reports leading up to that primary. They failed to file a supplemental report in June. They failed to file a number of disclosure reports leading up to the general, the 2-month, the 1-month, the 2-week. And on the next slide, you'll see that they also admit they failed to file and disclose the money being raised and how they were spending it for a runoff election that did not occur, but they were raising money for that at the time in anticipation of a potential runoff during the certification portion of the election. They also failed to file a supplemental disclosure report at the end of the year. And the final two on this slide, they failed to register as a ballot committee in 2019 and failed to file the disclosure report 15 days before that election. The final four violations of law, New Georgia Project and the Affiliated Action Fund have admitted they failed to disclose $4,216,000, $73.07, so a little over $4.2 million in contributions that they failed to disclose during the 2018 election, and they failed to disclose just over $3.2 million in expenditures that they should have reported to the state for public disclosure during that 2018 election for governor and other statewide offices in both the primary and general. They've also admitted they failed to disclose $646,000 in change during the 2019 MARTA referendum, and that they raised, and that they failed to disclose $173,000 in change in expenditures influencing with direct voter outreach, contact, electioneering, the MARTA referendum in expenditures in 2019. They've agreed to pay a fine in the amount of $300,000 to the state for these ethics violations. Wrapping up, I'll just say this $300,000, this certainly represents the largest fine ever imposed in Georgia's Ethics Commission, but it also appears to be the largest ethics fine that we've seen by any state ethics commission in the country related to an election or campaign finance issue. But commissioners, while this is a significant fine in scale, I believe it's also appropriate given the scope of which state law was violated in this case. This clearly represents the largest and most significant instance of an organization legally influencing our elections in Georgia at a statewide level that we've ever uncovered. And I think this sends a pretty clear message to the parties, to the public, and to potential bad actors moving forward, that if you break the law to influence our elections, we're going to be diligent in our pursuit, and we're going to hold you accountable for what you've done. For those reasons, commissioners, I ask that you approve this consent order, and with that, thank you, Mr. Chairman.
Before we move to any of the commissioners, Mr. Fox, I know that you're there on by Zoom. We'll give you the opportunity to make any kind of statement if you would like to do so.
Thank you, yes, very briefly. Can you hear me?
Yes, sir. Go ahead.
Thank you. Again, I'm David Fox for respondents, and I want to first thank the Commission for its consideration of this proposed order and for its accommodation in allowing me to address you remotely. And I want to thank as well Mr. Amati and Ms. Young for working with us on a resolution of this matter. The matter relates to events from more than 5 years ago, and respondents are eager to put the matter behind them. We've had a variety of disputes with the Commission over facts and law throughout this matter, and I will say I wasn't able to see Mr. Amati's slides right now, and we don't necessarily agree with everything that Mr. Amati just said, but at a fundamental level, respondents understand and respect the Commission's position on the facts and the law. And we believe that this is a reasonable resolution of this long-standing dispute that will enable everyone to move forward, and we thank the Commission for considering it.
Thank you, Mr. Fox. Commissioner Wise?
Yeah, and I think clearly the staff is due commendation for their diligence and their efforts on the behalf of the state. It's a remarkable effort to see this process. And it's not without commendation to New Georgia Project and their fund to be able to resolve this issue before the state.
Thank you, Commissioner Wise. I do have some remarks that I would like to make as well. I'm going to go back to highlight some of Mr. Amati's presentation, in particular with regard to the procedural aspects or procedural issues that have arisen in this case, I guess is the best way to put it. So if I'm understanding the timeline correctly, and Mr. Amati, I want you to correct me if I get off track here at some point, but the complaint was filed in September of 2019. And at the same time the complaint was filed, subpoenas were issued to the respondents. And nothing happened with respect to those subpoenas until we get to November of 2019, at which point in time the commission decided to file a motion to compel with regard to those subpoenas in Fulton County. Now, what ends up happening with regard to that Fulton County litigation is that it goes up to the Court of Appeals here in Georgia twice. In March of 2021, the Court of Appeals found in the Commission's favor, and in November of 2022, the Court of Appeals found in the Commission's favor. So then by November of 2023, which is more than 4 years later, Fulton County Superior Court orders compliance with those subpoenas. Now, at least at some point in time, in conjunction with what was going on in Fulton County, we have litigation that also developed in Gwinnett County because the respondents filed a motion to quash subpoenas over there. It goes up to the Court of Appeals again here in Georgia in September of 2021, and for the third time on these issues relating to these subpoenas, the Court of Appeals decides in favor of the commission, actually grants the commissioner's motion to dismiss the appeal. So we've got 3 times that the case went up to the Georgia Court of Appeals. Bank records are provided to the commission finally in March of 2022. Based on the information that's obtained from the bank records in June of 2022, that's when the amended complaint is filed. We finally get to have a preliminary hearing and find probable cause in August of 2022. And in that regard, we've got the case pending at this point in OSA for an ALJ's consideration after the presentation of evidence in the event this consent order would not be adopted by the commission. And again, about 30 days after we have the preliminary hearing here, that's when the federal lawsuit is filed. It goes up again to the Court of Appeals, this time to the 11th Circuit Court of Appeals, and the Court of Appeals again sides for the commission and dismisses the action. So I go back over that, and this will sort of go along with what Commissioner Wise said. I think it's important for me and the rest of the commission to thank commission staff, thank the Attorney General's office with doing what they were charged with doing in this case, which is enforcing the Campaign Finance Act. If we look at this proposed consent order, we've got findings of fact summarizing the commission's determination of facts based on its investigation in this case. More importantly, as Mr. Amati's already addressed, we've got a section in here that's conclusions of law setting forth the commission's allegations based on its investigation. I think it's particularly important to look at items in the consent order 11, 12, 15, and 16. I wanted to bring this up again. I don't think that Mr. Amati's slide necessarily corresponded with what is in the consent order.
Right.
So I want to make sure that in the consent order, 4 of the items that Mr. Amati was referring to, 11, 12, 15, and 16, and again, I'm not trying to say any one violation out of the 16 is necessarily more important than the others, but number 11 is that the respondents violated 21.534 F2A when they failed to disclose approximately $4.2 million in contributions. The next one is that they failed to disclose approximately $3.2 million in expenditures. 15 is that they failed to disclose approximately $646,000 in contributions. And 16 is that they failed to disclose approximately $174,000 in expenditures. And then I think the most important part of this consent order is what is, I guess it's considered the 4th paragraph under the agreement. And it says, respondents represent that the foregoing findings of fact are true, agree with the conclusions of law, and further agree to abide by all terms of this order. So I put all of this together, for one purpose. We're now where we are because of the procedural complexities that occurred in this case, and it's where I feel we should have been back in 2021 or 2022, at which point this case should have been resolved. But because of the protracted litigation, we didn't get to this point until 2025. But again, I want to thank Commission staff, the Attorney General's office for not giving up on this, for sticking with it for a period of more than 5 years, and getting the result that we've gotten here today. So again, thank you, Mr. Amati. I would thank Ms. Young. I know that she wasn't here today, but I'm sure that you will be able to convey that to her. Thank you very much. Commissioner Thompson?
I'm gonna probably say some of the same things you did in a different way. But first, I wanna say that, not to take away from this fund, okay? Because it is significant, and not to take away from the agency staff's work, because it is impressive to, fight this fight as long as you guys did, with personal attacks through the press and social media at times. You guys stuck in there. However, I think actions like this should be criminal because of the significant impact secret money can have on elections. Organizations attempting to keep their election spending secret is shameful and does a disservice to our elections and voters. To continually stall and not cooperate with our investigation is extremely disheartening. And if it wasn't for people like Joe Kuzak, who's here, Mr. Amati and the rest of the staff, this would have gone away. They would have got worn down, and with the AG's support, we were able to keep going as well. But these kind of maneuvers to try for justice or for light to come into elections is absolutely disgusting. With that said, I will probably support this because currently this kind of action under our jurisdiction cannot be criminal, or we do not have that criminal power.
Anything further from the commissioners? Which number are you in, 18?
18. I am delighted that we have a consent order in front of us. I was a fairly new commissioner when the 2022 hearing took place, and I've been through the 11th Circuit and District Court, and I'm glad it's resolved. Really, all I'm going to say is I'm going to agree with Mr. Fox's point that they signed a consent order, and so although I agree with Mr. Amati's presentation, and I agreed with the presentation in 2022 personally, they've admitted to what they admit in the consent order, and that's really all that's in front of us. And I think they were wise to do so, but they obviously have their own reasons to move on, and I think that's in everyone's interest. But since Mr. Fox is not here, I wanted to say his point was well taken. They signed it for reasons of their own, and that's why we're here.
Thank you, Commissioner Burge. Any other questions, comments from the commissioners? All right, hearing none, I'll go ahead and make a motion. I make a motion that we adopt and approve the consent order presented in case number 2019-0050 PC in the matter of New Georgia Project, Inc. and New Georgia Project Action Fund, Inc. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Hearing none, that motion carries. That takes us outside item number 4 in the agenda. Item 5 in the agenda are cases A through F, which constitute administrative dismissals. Mr. Amati, is there anything that needs to be addressed from the commission staff with regard to the administrative dismissals? No. Is there anything, any questions, comments from the commissioners with regard to any of the administrative dismissals that are included here? All right, hearing none, no action is required. We will go ahead and move to item number 6 on the agenda, which is public comment. Do we have anyone that signed up for public comment? Mr. Easterwood, no? No, okay. I'll go ahead and move then to item number 7 on the agenda. I'll move to adjourn the meeting. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right, meeting's adjourned. Thanks and other.